Yes, if you would.
This is an appeal in the matter of Purkiss and Kennedy and others.
Yes, Mr. Sims, we have read the judge's judgment and the skeleton arguments. We have noted your objection to the introduction of the Morse report, but I don't propose to waste much time on it now. We have the objection and the reasons for it, and we will deal with it in the judgment.
My lord, we're more than happy with that approach. We weren't concerned about your lordship's looking at it or considering it, but your lordship will have seen the way we put it in our written argument. I'll leave it there. So, my lords, in those circumstances, I should make the introductions first, of course. I appear with my now co-leader, Mr Passfield of King's Counsel, and we represent the appellant, and Mr Bayfield of King's Counsel appears with Mr Colclough and Mr Tucker Harrison for the respondents. In relation to the batting order, so to speak, subject to anything that your lordships have to say about it, what we propose to do is to open our appeal for my learned friends to then respond to that appeal and open their response notice points, and for us then to respond to their response notice points and reply.
Yep.
And if my learned friend thinks there's a very brief point arising out of our response to his response notice on a point of law or similar, then of course he can stand up and deal with that briefly at the end. That does leave the question of discretion, but it seemed logical for us to deal with it in that way, and then to revisit with your lordships whether or not you want to hear submissions from us on discretion now or not, and whether or not you want to hear the argument about whether you should deal with it or not.
I wasn't quite clear whether we are being asked to exercise discretion if we get that far, or whether everybody agrees it should go back to the judge.
Well, as matters currently stand, we thought actually looking at the arguments raised by my learned friends, they were reasonably capable of being dealt with by this court. Right. But it may depend to some extent on the conclusions you reach on the first 2 points, yes, for obvious reasons. So it seems sensible for us to deal with this in that way. There probably is quite a full day already with those submissions, and we maybe revisit that at the end, and it may well be that we can deal with that on another occasion rather than today if we're short of time. So in those circumstances, I should also say that it's proposed that I open our appeal, but that my own friend Mr Passfield deals with any points arising out of the response notice. So in effect, the transaction and undervalue arguments.
Yes.
But to the extent that there are overlap points, we'll hope to assist your lordships with those whilst either of us are on our feet and deal with it that way to the extent we can. And so unless there's anything further by way of batting order or housekeeping, it probably makes sense for me to crack on and open.
Yes, by all means.
In relation to the structure of our submissions, just to give you a few headings in relation to the order in which I intend to take matters, subject to obviously any contrary direction from the court or points which we explore with the court. The first is an introduction and some headline submissions, which we advance in support of the proposition that the appeal on purpose should be allowed. The second is looking at some of the background, principally by reference to the relevant passages in the judgment, but also picking up on 1 or 2 points which we will then revisit more in the context of our submissions on the reasoning, but just to introduce your lordships briefly to that. Thirdly, our case on purpose in the court below and how we put our case in this court, by reference to our pleading and the way we advanced it in the court below. And fourthly, our submissions on the proper interpretation of section 423 and submissions on the authorities. And then finally, part 5, revisiting the reasoning of the judge below and identifying the principal reasons why we submit.
Say that again, I didn't hear.
Part 5 being looking again at the reasoning of the judge in the court below and why we say he was wrong by reference to the, obviously the starting point is our written argument, seeking to develop the points in our written argument and to refine them as appropriate with your lordships.
Right, well, I mean, those headings look as though they're concentrating on what you call your primary case. Where does your secondary case fit in?
No, they're intended to deal with both.
Both, all right.
Yes. So we have very much in mind that your lordships will want to hear from us on both.
Yes.
And I intend to try and maintain reasonable balance between the two. Your Lordships will probably appreciate that our primary case is focused on the question of whether or not the purpose in this case was a Section 423 purpose, irrespective of the question of in the event that it failed, whereas the secondary case is very much focusing on the question of in the event that it failed,
Yes.
what then?
Yes.
There is potentially some overlap between the two, because to the extent someone might adduce evidence on the secondary case, that might also have an impact on the primary case. But logically, it makes sense, I think, for us to deal with that order. But we do very much have in mind addressing both limbs of our case.
Right.
So part one then, and introduction and headline observations. My lords, in relation to the position in relation to this case, it's worth observing that quite some time ago, in 1992, by reference to the earlier decision in the Duke of Westminster in the House of Lords and Ensign tankers, it was observed by Lord Templeman that gardeners do not work for dukes on half wages. That was a wry remark by Lord Templeman at Authorities Bundle tab 562. We submit, nor do modern day employees work for umbrella companies for less than 20% wages. You see the calculation of 20% by looking at the calculation the judge performed in paragraph 10 of the judgment. What we submit lies at the heart of this case was an artificial tax avoidance scheme whereby the company disguised the respondent's earnings by entering into the composite transactions as found by the judge. And the ultimate issue, whether we're looking at it on the basis of our primary or secondary case, is whether the company had a Section 423 purpose when entering into each of the composite transactions as found by the judge, which in effect represented the implementation of the scheme which had been marketed to the respondents who had joined the company as employees in order to participate in the scheme. The entry into the transactions to implement the scheme was the company's only business, and the ineffective nature of what has subsequently been found to be an unlawful and ineffective scheme rendered the company insolvent immediately. So in relation to some of the headline points or propositions which we seek to develop on this appeal, the first is that there is nothing in a straightforward reading of Section 423 reflecting an approach which is consistent with the guidance given recently by the Supreme Court in El Husseini, which is relatively hot off the press, and we've included at tab 34 of the authorities bundles for your lordships at page 932. We'll come back to that briefly.
So I missed the beginning of that sentence. There's nothing in a straightforward reading of Section 423.
Yes, comma, reflecting an approach consistent with the guidance given very recently by the Supreme Court in El Husseini, comma, which excludes tax avoidance per se, qualifying as a Section 423 purpose, let alone the purpose of a disguised remuneration scheme such as the present one. So that's our point number one. Our point number two is we're not contending on this appeal that all tax avoidance cases will necessarily fall within Section 423. Simply that the tax avoidance purpose in this case, based as it was on disguised remuneration scheme, should have been identified by the judge as having a purpose falling within Section 423. And it was because of his threshold conclusion, if you like, that the purpose which we'd identified didn't fall within Section 423. In our respectful submission, he failed to go on and consider the particular features of this scheme, either on our primary case or our secondary case, in in a manner which disclose that they do disclose a Section 423 purpose.
Just to unpack that for me, because I'm
Yes.
not sure I entirely follow it. If I pay money into an ISA,
Yes.
I do that partly because I think it's a good investment and partly because I know I won't pay capital gains tax on any profit that I make. That's a mixed purpose, and one of my mixed purposes is to avoid tax. Is that a Section 423 purpose?
Well, in relation to the question of that particular example, the question arises, on the facts of the particular case, is the person seeking to prejudice the interests of HMRC?
Well, I am, because they're not going to collect capital gains tax if I make a profit on my ISA investments.
Yes, so in that scenario, you may have, subject to the findings of fact, a Section 4233 purpose. You wouldn't necessarily have a Section 423 claim, because it's not obvious on that scenario, if your tax planning is legitimate, successful, who the victim is. You don't.
The victim is HMRC because they're not going to collect capital gains tax. That's obvious, isn't it?
Well, no, because if the tax planning is lawful and effective, then the transaction overall hasn't impacted on HMRC such as to prejudice its interests as a creditor or someone who may be viewed as in effect looking through the creditor relationship vis-a-vis the debtor. So that there is, on that example, no victim who could bring a claim, because HMRC can't turn around and say in relation to legitimate tax avoidance planning that it is a victim. It has no prejudice suffered to it if the law has concluded that the tax avoidance is effective and lawful. So
this is what I'm not quite following. If I do something which is mandated by the tax code, pay money into it,
yes,
that's not within Section 423.
It doesn't fall within Section 423 for a number of reasons.
Yeah.
Not simply, the focus obviously for this appeal is on the question of purpose, but one of the submissions which I'll seek to develop is you have to look at Section 423 in relation to all its component parts. Before you even get into Section 423, you have to have a victim or an office holder who represents a class of victims who can bring the claim. And on the homely examples, if I can put it that way, that my respondents identify, in relation to all of those, there isn't actually an apparent victim because they're positing a successful tax avoidance scheme.
But the difference between an artificial scheme to avoid tax,
yes,
and what you just say is legitimate tax mitigation,
yes,
tax avoidance, is not to do with the purpose, is it? It's to do with the means by which you wish to accomplish the same purpose, namely not to pay tax.
Well, I wouldn't disagree with this, that there is an additional layer to consider in relation to unlawful or illegitimate tax avoidance schemes, which is focusing on the way in which the tax avoidance scheme is carried out. So I don't demur from that proposition. So if your lordships were against me on the question of tax avoidance per se, the next logical question is the tax avoidance scheme as operated in the way this was, does that disclose a Section 423 purpose? And our submission in that respect is that what lies at the centre of this tax avoidance scheme is the disguise. So they are seeking to anticipate a tax liability arising in relation to remuneration, and they're seeking to disguise that through an artificial scheme which ultimately is unsuccessful. And that in itself can constitute prejudice for the purposes of Section 423, because you have precisely in mind the liability which is arising, and you're seeking to prejudice the person in relation to the claim which they may make in that respect by disguising something which might otherwise look like a simple remuneration. So I think there are three different responses I give to your lordship's answer. The first is you have to get into section 43 in the first place. You have to establish a victim. We don't on the ISA example. Sorry? Yes, I mean, on the ISA example, in addition, I don't think there is an undervalue element either, probably, but you could try and modify the facts to introduce undervalue in some way. But on that fact, as it happens, I think on that postulation that you'd obviously need
concentrating on your submissions on purpose.
Yes, exactly. Yes, my lord, we would say you don't even get into a section 43 application for the reasons I've identified. Our secondary submission is yes, that is capable of constituting section 43 purpose. And then a third is, if your lordships are against me on that the particular scheme in this case, in the way that it was carried out, discloses section 43 because of the disguise. So that's where we would lay our submissions in that respect. And we recognise that the second limb of that submission may pose some much wider questions than our third limb does.
What does disguise mean? I mean, I'm not clear how much the revenue knew about this particular scheme, but suppose that the scheme had been disclosed to the revenue and they had known that this company was operating the scheme and they had known that the participants were receiving money in this way. Disguise?
So the particular elements of disguise which we say are features of this case, which are features which are actually quite common to these schemes but that exist in this case, are number one, the way that the scheme is structured is in effect to try and split up the remuneration and to divert the section of it via the offshore trust and then settle the money into a discretionary trust which then cascades down through loans to the ultimate respondent. And on the unusual facts of this case, it was accepted right from the outset that was the composite transaction which we were dealing with for present purposes. And so the elements of the disguise were everyone looking prospectively at the transaction are asking themselves the question, this is going to be employment income, how do we deal with that? And the element of this disguise is to try and, in effect, remove from HMRC's visibility.
When you say visibility,
yes,
I'm assuming that HMRC know all about it. So what you mean is not that they don't know about
not
it, but it's an attempt to remove from the tax net.
Exactly, so you're structuring it. And there may be various different degrees of what disclosure is given to HMRC in relation to the scheme.
Well, they got a DOTAS number, as was said in the interview.
I think so. I think that's right. So I think the scheme overall, that perhaps not necessarily this company, but the Ethos scheme was disclosed and given a DOTAS number, as I understand it from the evidence in the court below.
Yeah.
So I'm not saying that the disguise is necessarily that you don't disclose the scheme. The disguise is that you are artificially seeking to separate out into chunks the remuneration in order to try and get the benefit of the argument that, well, the amount paid into the trust it is not to be treated as our taxable income for employment purposes.
I mean, plainly, the idea was that sums that would otherwise have been paid taxable under whichever schedule to the self-employed individuals,
yes,
would instead escape tax because they were routed through to the trust.
No one would have been going into the scheme but for that.
But we suppose, for the purposes of at least your first argument, that was believed to work.
Yes.
So where's the disguise? They're merely recharacterising sums that would otherwise be taxable one way as exempt on another way.
The element of disguise really is that the way that it's structured and set up is the company, whilst it may disclose that there's this DOTAS number, they're not actually giving visibility to HMRC in relation to this is what is the earnings of this person, and this chunk is then being paid out to the offshore trust, and then this amount is coming back. They simply say, we don't know, we have nothing to do with that. The trust is offshore, you'll have to ask the trust. And therefore, it's very difficult actually to get to the end to work out, well, have they actually received the loans? Have the loans been repaid? All those sorts of factual questions make it much harder for HMRC to unravel it. And HMRC don't even know from the accounts that these are payments made to the trust. And that was a failing of the judge at first instance in not appreciating that. They simply referred to as other staff costs. They're not actually disclosed as paid to the trust. And when the question was asked by HMRC, how much money has been paid out to the trust, they didn't answer that. And we say the judge got that point wrong as well. I appreciate these are all factors which lean more heavily into our secondary case than our primary case, but it's useful, I think, to explore them because they do have an impact on our primary case in this sense that we say that these features which the company knows about and the respondents, as it happens, also know about, because that's the reason why they joined the scheme, are seeking to disguise from HMRC as a matter of substance, even if they're disclosing the tax scheme overall, how much money is paid out in relation to each of them to the trust, how much is then advanced to the sub-trust when the sub-trust funds are then paid in terms of loans and whether or not they are truly recallable. And it was our case in the court below. These weren't truly recallable loans. The scheme doesn't work if these are truly recallable loans. And what you're seeking to do really here is to wave a magic wand and try and wave away your tax liability in relation.
Well, that's why it didn't work. So the
Yes.
Supreme Court said in the Rangers case.
Yes, exactly. So, but to come back to the question as to disguise, hopefully that answers your question in that respect as to what we say the disguise is. We're not saying that there is any, in fact, material difference between whether you have a total tax number or not for present purposes. But both the company and the participants in the scheme know, we can see this from the materials, that an inherent feature of the scheme is these payments to the trust and the loans aren't going to be disclosed to HMRC. You don't need to disclose them, we're not going to disclose them. And obviously those arguments were subsequently, as your lordship has identified, found to miss the key point, which I think was drawn out by Rangers, which is, well, actually the key question is in the interpretation of the underlying legislation, is you don't actually have to show the payment has been made to the employee and received by the employee. And so if there's a redirection of those monies, then it doesn't work. So I got slightly diverted away from my points, but I think I was on our second point.
Yeah.
And on our third point, what we say in relation to the central flaw of the judge's conclusion on our primary purpose case, and really the key paragraph in the judgment in this respect is paragraph 46 B, that where the purpose is to ensure an actual potential creditor has no claim made against you as debtor. This is not a section 423 purpose. Maybe assistance just to open it up and look at the precise words used by the judge. If your lordship want the references, it's behind tab 7 and it's page 87. And the key passage really we would respectfully submit is in 46 and it's in little b.
Yep.
And so the objection by the judge in effect was you applicant falls into a category case which falls outside section 423, so we don't even get into the types of arguments I've been exploring with your lordship, because the purpose was HMRC would have no claim which it could make, ergo you fall outside section 423. We respectfully submit that is not necessarily inconsistent with a purpose to prejudice a claim which HMRC were making at the time or might make in the future. Whether it does on the facts, the judge didn't really then engage with, because he simply cut us off at the pass, so to speak, by saying, well, your case just doesn't fall within section 423 purpose. And in our respect for submission, that conclusion, the logic of that reasoning would apply, for example, to a debtor who delays a creditor as part of a value depleting transaction. So, for example, they go past the limitation period and have no claim they can make. In our respect for submission, it's a conclusion which undermines a statute which is aimed at ensuring debts are paid before gifts are made, and positively encourages raids on the public purse, which positively encourages ingenious lawyers and accountants to come up with search for new business opportunities and promote these schemes. The answer to the debate in this respect is to ask whether the way in which the tax avoidance was carried out, its objects as gleaned from its design, fall within the words and purpose of section 423. And in our respect for submission, a disguised remuneration scheme such as the present can, as a matter of principle, fall within section 423 and should be found to fall within section 423 for the reasons we briefly outlined.
Can I just understand your limitation example? How does that work?
So for example, if you have a person who is a creditor who's making a claim, and I enter into a transaction with another party, which I know is a value depleting transaction, but perhaps I have some interest in it through a third party. And I know that there's a critical time period which we go past if I delay, hinder in some way an understanding of what's happened in relation to that transaction. So if the purpose of the transaction is to transfer an asset away and to delay that person from being able to make a claim for, let's say, a period of 6 months, and the limitation period is coming up in 5 months, so to push someone past the limitation period, that is, to use the judge's words, a purpose to ensure that the creditor would have no claim, because you can't bring a claim after that period of time.
Well, he'd lose a claim. He has a claim, he'd lose it.
Well, yes, so on that scenario, you're positing an example of an actual creditor. But is it really very much different in circumstances where the statute has making a claim or may make a claim, to contemplate a scenario where someone may do that in the future, even though they haven't yet presented their claim or it hasn't crystallised, if the purpose is the same? So really what we're saying is that simply because you have an example of someone who seeks to stop someone from being able to make a claim, and under the law as it stands, on that hypothetical scenario, you're successful in pushing them past the limitation period, that shouldn't take us outside section 4233. And again, to go back to the reason why, inherent probably within it lies some feature of where you carry that out, from which you can disclose a prejudice. So hindering, delaying, defeating, defrauding, etc. Disguising, we would say, naturally falls within that category. It may be, your lordships would conclude, without that feature, then we're not within the section 4233 purpose. It's obviously against my second limb of my submission, but undoubtedly we'd be within limb 3, if I can put it that way. The fourth point, and this is a feature which we submit features heavily in the paragraphs which lead up to paragraph 46 and which follow it, is that the judge wrongly characterised our case in the court below on the basis that in some way the HMRC claim was, or the target was hypothetical. And you see a number of references in his lordship's judgment to hypothetical. The composite transaction was defined by the judge at paragraphs, I think it's 30 to 34, and it takes as its starting point that the respondent has become an employee and is providing services for which it receives remuneration. The liability to deduct PAYE employment income arises before the redirection is made via the trust, and the use of the loans, which of course we say everyone knows will not be recalled.
But the judge's reasons about his discussion of whether the claim's hypothetical in paragraph 47 is really an aside, isn't it? He's already decided in paragraph 46 that there is no section 423 prohibited purpose.
It is. I thought it was a
Assume you're right about that. It doesn't affect his reasoning.
No, it doesn't. We still have to persuade your lordships that under the three limbs of our submissions, we have at least limb 2 or 3 as part of that. We recognise that. And it may well be I just don't need to say much more about it on this appeal, but we were just conscious of the fact that I think it's only get to paragraph 48 the judge actually deals with our pleaded case and the case we argued below. In fairness to the judge, perhaps one of the reasons why he ended up articulating in that way is because an unusual facts of this case, the purpose of the respondents in entering into the scheme informs the ascertaining of why the scheme was designed in the way it was. So we weren't pushing back on the idea that that was relevant as a matter of evidence, but as a matter of law, as a matter of our pleaded case, it's the composite transaction, it's the company's purpose for entering into that composite transaction. And when it does so, there's nothing hypothetical about the HMRC liability. It's the very thing which is the target of the scheme. And it may well be that a closer reading of the judgment discloses that's why we have a lot of that discussion rather than discussion about actually the features of this scheme, which we submit are critical to the findings that should have been made or weren't made, whichever way you put it. The fifth point is, and this is more focusing on our secondary case on purpose, that there can be no real argument that the company and those whose mind is to be attributed to the company would have appreciated that there was a risk of challenge. The risk of challenge is pregnant in the materials that are advanced. Of course, they seek to reassure those who are seeking to enter into the scheme. As it happens in this case, there was no direct advice given to the company. It was one step removed, if you like. That Mr. Webster obtained advice through a contract with Montpellier Tax Consultants, and then he set up the company. So there wasn't actually any direct advice to the company which could be relied on by the company in that way. It wasn't a client. But I don't think anyone can really argue with the notion that a challenge by HMRC was a very substantial risk. And the design of the scheme by the company was such that in the event of a successful challenge or claim by HMRC, the liability would of course fall primarily on the company, which had no resources to meet it because it only had £100 of share capital and in effect immediately was rendered insolvent as soon as the first composite transaction was being entered into. And opacity in relation to the remuneration received by each of the respondents via the magic circle, if I can put it that way, that the composite transactions created. The use of an offshore trust in our respectful submission is a factor. The judge, I think, posited in one of his paragraphs that it wasn't clear to him how we were putting our case in that respect. And it was because both of the features the judge refers to were relied on in our pleaded case and relied on in our oral submissions.
This goes to the secondary case, does it?
The secondary case, yeah. Yes. So on the secondary case, your lordships will recall, I think in in paragraph 52 or thereabouts. The judge says along the lines of there wasn't really any clarity as to what we were relying on. It's a paragraph 52 at page 89, second sentence.
Yeah.
And both of those features were relied on by us in the court below and relied on by us on this appeal. So the feature of the company being primarily liable, of course, is a relevant feature to take into account when asking oneself the question, in the event of the failure, who does the liability primarily fall on?
One thing I'm not clear about, supposing that the scheme had worked,
Yes.
did that depend on the trust being offshore?
Well, it depends on the reasons why the scheme is found to work, I suppose, if you see what I mean.
If one looked, I don't know how much material you have access to,
Yes.
if one looked at the Montpellier package
Yes,
or the advice that Mr Argles gave on the scheme,
yes.
would one find in that as a matter of tax law, on the assumption that the scheme worked,
It needs to be offshore. No, I don't think so. I don't think it was suggested it needed to be offshore. No, I think the second iteration of the scheme might have involved that feature. You may recall the second iteration of the scheme involved scope, where they, after I think it was December 2010, when Parliament said we're going to bring in legislation to stop this happening, they then modified the scheme so that the relevant employer was an entity in Jersey which was set up by a cousin of Mr Webster. And that then, I think, did become a scenario where they were positively seeking to use an offshore trust as an employer in order to try and make the scheme work. But there's nothing I've seen in the materials to suggest necessarily needed to be an offshore trust for the purpose of this particular tax planning to work.
and just so I understand, not that we've got it, but for the purposes of the trial before the judge, did you have the Montpellier package and the advice from Mr Argles?
Yes, it was exhibited from
Yes,
memory.
that's-
Yes, it was. Yes. The advice, it was a curious advice. Often these tax advices I find quite curious because the reasoning you see in them doesn't necessarily seem to engage with the issues which, with the benefit of hindsight, you can see are the key issues. But in fairness to those who were advising at the time, they perhaps are not necessarily anticipating the redirection argument, for example, which was raised in Ranges. But yes, that material was before the judge. So the short point is that what was the reason there for the offshore trust? And in our respectful submission, it was there for two reasons. Principally, one, obviously, makes it more difficult to follow the assets if you have an asset trail which leads via foreign jurisdiction or offshore jurisdiction. But secondly, its opacity, it makes it harder for you to get information. Will those persons, those trustees, respond to requests for information? Will they give you the information? Can you then therefore work out and follow the trail? It just makes it harder for a UK liquidator to unravel the whole package, if I can put it that way. And in our respectful submissions, those features were not merely incidental, but the heart of a deliberate design. My lords, we in the course of our preparations thought that actually some of the cases in the context of unallowable purpose, in the context of the tax cases, which your lordships have recently looked at in case for GATI, provide a useful analysis in relation to this point, and these are one of the authorities which we provided to your lordship late. So apologies for that. There were two additions, I think, to the final iteration of the electronic bundle your lordships have. I think that there was an addition on the earlier version at tab 36 with Mr Justice Calver's judgment at first instance in Investbank, which I think did make the cut.
Yes.
But tabs 37, which was the extracts from the court report, and tab 38, which was the JTI,
yeah.
didn't, I think, make the
Yeah.
cut. So we've handed those up, and your lordship
Yes,
should
I've
find
got
those. I'm grateful. And your lordships, I think, were, at least two of you anyway, were sitting on that tribunal, so I don't intend to dwell on it further beyond noting that it seemed to us that the passages in particular in paragraphs 26 and 27 were useful in terms of an analytical framework when considering the question of purpose. And in particular, we would invite your lordships to note paragraph 27 little e, where by reference to the earlier decision, I think in BlackRock, there's reference to some results or consequences that are so inevitably and inextricably involved in an activity that unless they're merely incidental, there must be a purpose for it. It may be thought that you get to that same conclusion through some of the section 423 cases. We thought that was a useful analysis to emphasise for the purposes of our secondary case, because our first and main objection point as regards why we say the judge was wrong in relation to our secondary case was to, in effect, not make use of what can properly be inferred is the purpose through entering into a transaction which involves a payment to an offshore trust, which in circumstances where the scheme is not effective will result in a liability primarily resting on the company in circumstances which it has no recourse to the trust to recover that money, and in circumstances where it's difficult to actually work out what individual sums should be allocated to individual employees in relation to the structure. There is also a secondary element to our secondary case, if I can put it that way, or a second limb to it, which focuses in particular on the evidence the judge did look at in paragraphs 53 to 55 of the judgment, where, in our respectful submission, he simply got the evidence wrong in relation to certain features, or failed to draw inferences which he ought to have done. We recognise that
That's a hard one to succeed on appeal, isn't it?
we recognise that we're in, I think, my Lord Justice Lewison's territory of age, and in relation to this second limb of our secondary case, we need to be in the territory of demonstrably wrong, plainly wrong. Use what language you want. The only points we were to draw to your lordship's attention in relation to that as features which perhaps make our task easier in this case than it might otherwise be. And if I put it this way, we may be at the less reluctant end of the scale, though of course still reluctant scale. But the less reluctant end of the scale is that this wasn't a trial where actually there was any evidence from the respondents or indeed any of the actors who played a role. We did call Mr Purkiss to give evidence, and he gave evidence in accordance with the two witness statements which are included in the supplemental bundle. There was very little cross-examination of him, which perhaps is unsurprising because he was a stranger to the events in any event. But he wasn't challenged on the key features of the transaction because they weren't in fact controversial. So in those circumstances, it's not we're not in a case where which is much more difficult, where we have oral evidence and findings by reference to oral evidence, which has to be thrown into the mix as well. But of course, we recognise that the starting point is reluctance, nevertheless. So those were the headline points that we wanted to make to sort of set the scene, so to speak. And hopefully those give your lordships the main points we wanted to draw out in our submissions. And now I was going to propose to move to heading 2, unless there's anything further your lordship wanted to raise at the outset, so to speak. And just briefly trace through the background. It may be that if your lordships have recently read the judgment and have it sort of very clearly in mind, I can take this section quite quickly. But nevertheless,
Well, I think you can take it quickly.
Okay, good. Well, in which case, rather than going to the judgment itself, we can have it open if you like. I will just simply give your lordships the references and the points and skip through it. It's core bundle tab 771 is where it starts, the background section. So the first point your lordships will see is that so far as the relevant individuals are concerned, the story starts with Mr Webster. He becomes the initial director, but by the time of the transactions themselves, Mr Clark has become the director, though Mr Webster, material times for the purposes of this claim, remains the 100% shareholding. And in relation to the company's structure, I don't think it's actually expressly referred to by the judge in this part of his judgment, but you can see from the supplemental bundle at tab 3 at B17 and then at B20 the share capital of £100 point. We then have reference to the use of the trust in paragraph 8 and the fee. And then you see the judge outlines how the scheme operated in paragraph 9.
Yeah.
And then 10, we have the worked example, which your lordship will note, in effect, inform the point I made at the outset about the percentage of wages, which in effect is being treated for the purposes of this scheme as being allocated to the employee for PAYE national insurance purposes. And the judge notes the effect of that, obviously, is it ends up in a rather attractive position for the person in the example here, for the reasons which are obvious, which is that you are, in relation to the vast bulk of your remuneration, not actually getting taxed on it at all. The judge then refers to the introductory letter, paragraph 12, and you'll note the feature of the loans is sort of central to an understanding of how this works and how the respondent ultimately receives their remuneration. And you will note that it's made very clear in the covering introductory letter by Mr Clark that the loans will not be reported to HMRC, and it's suggested they're not a taxable benefit of your employment. And then there's the document which was annexed to that letter, a frequently asked questions document, which you'll note also emphasises, interestingly, that loans are not commercial loans and not interest bearing. All loans are recordable. Well, technically, they may have been recordable, but everyone obviously understood for this scheme to work that they wouldn't be recalled. In relation to the other features, you can see that there's then again reference to HMRC not being informed of the loans. There's reference to support from advice in relation to any HMRC investigation and challenges and how this is robust and resistant to challenge. Of course, they can offer no guarantees in relation to the actual efficacy of it. So that was set out in paragraph 12. Paragraph 13, we then have the judge recording that very soon after this scheme started operating, I think it was March 2009 was the first payment, we have Spotlight number 5 published by HMRC, making clear as to what HMRC's attitude is in relation to these particular types of scheme, and whether or not the respondents themselves were alive to that. It's reasonable to draw the conclusion that those involved in promoting of schemes of this type and markets to them would have appreciated that was HMRC's attitude. And then we have, as I've said in paragraph 14, the reference to the government.
Wait a minute. It's not good enough, is it, for you to say people in their position would have appreciated? At this point, you've got to say they did.
Well, yes, the natural inference to draw is that they did, yes. I should make that clear. You're absolutely right. We have to positively establish subjective knowledge on
Yeah.
the part of the company.
So just to be clear, for this purpose, the understanding of all the individual respondents really doesn't matter.
It doesn't matter, yes.
It's the understanding of those involved with the company who would be Mr Webster or Mr Clark. Mr Clark has become the director by this point.
Exactly, yes. So Mr Webster stroke Mr Clark. In reality, Mr Clark was put in there by Mr Webster. I think you can see from the transcript there was a slightly odd arrangement whereby it said that Mr Clark was with Mr Webster. Mr Webster was with Mr Clark's ex-wife, and the payments which Mr Webster received were in effect the way that Mr Clark was being paid back. That was the explanation given in the interview. Mr Webster, as it happened, was paid the most out of everyone. He received payments to the trust were allocated to him in the sum of 163,200 in 2009-2010. That's call bundle tab 11, page 136. So going back though to the situation, we of course then have some correspondence with HMRC in 2011. I'll come back to the detail of that for the purposes of our secondary case, and then in 2012, and then HMRC then raised their assessments on the 4th of December 2012, which is referred to by the judge in paragraph 17. The response by the company directors was to place the company into creditors' voluntary liquidation, and we see that in paragraph 18. And the debt which HMRC submitted was as stated by the judge in paragraph 19. That was by reference to the period in question, which we're dealing with. We also advanced in the court below at an earlier stage a claim in relation to the later period, but that was based on an estimate by us rather than an assessment by HMRC.
The judge was concerned with the tax years 2008 to 9 and 2009 to 10, as I understand it.
Exactly, yes. So
what happened in 2011
is
only peripherally relevant,
is
isn't it?
only relevant to the extent it formed part of our pleaded case that when assessing whether or not the company has a Section 423 purpose for the purpose of this earlier period, look what they did when HMRC published its position in December. Sorry, the government published its position in December 2010. They set up another entity in Jersey for the purposes of trying to continue, notwithstanding the fact that HMRC had identified this as an area.
Is that right?
Yes.
The way the judgment reads is that the change to the scheme was in response to draft legislation.
Draft legislation, yes. Sorry, did I misspeak? I think I said HMRC, didn't I? Yes, I should have said draft legislation.
What they said in their FAQs was this works, but the legislation might change. Not HMRC might succeed in challenging it.
No, you're right. You're right.
The legislation might change. So then the government published draft legislation designed to tackle what was being seen as tax avoidance, and so they modified the scheme.
Yes. So, my lord, I won't quibble with either of that. We don't demur from the fact that they were seeking to try and portray the best possible light, if you like, in order to attract people to the scheme.
Yeah.
And they were seeking to emphasise the positives, downplay the risks, and obviously upplay the upsides. But overall, what we can see is that this was in reality, there was a situation which was if you think about it objectively, commercially, from the company's perspective, and the lack of capital. In the event that the scheme failed, then they were leaving their creditors unpaid. It was simple as that. This is not, unlike cases like Assertis, for example, this is not a case of a company which has a successful business, which has plenty of assets, and the person who is cross-examined at trial says, well, yes, if it did fail, there was no problem because the company had lots of assets, and in relation to the
Just pause a moment. Would everybody who's got a phone on, please turn it off?
I'm grateful. So in relation to the position, in relation to, in the event the scheme fails, this is very different from cases like Assertis, where the position is that the person gives evidence at trial to, the main director gave evidence at trial in Assertis, for example, to say, well, the company has lots of assets, and I also personally have lots of assets, so it's not an issue. And that, on our secondary case, that obviously is very different from this case. As it happens, in cases like that, that type of evidence also has the potential to undermine what we might describe as our primary case, because the person is turning around and saying, well, actually, my intention, there's no part of my subjective intention to prejudice the interests of HMRC in relation to this, because actually I didn't think it was going to be prejudiced either way, whether it succeeded or failed. So that's a distinguishing factor, we would say, in cases like Assertis. In the case of Marylebone Warwick, which is the other first instance decision that the judge referred to, it's a difficult case for us to understand in terms of rationalisation. It's of course not binding on your lordships in the event, but I think I should briefly go to that case in due course just to show your lordships what we say about that. But again, it was, as a starting point, a very different case from this one. There was a separate business activity, and then the EBT, or the scheme, is bolted onto it. Again, in that case, there were some positive findings that this was about incentivisation and remuneration for these employees to keep hold. It's very different from the scenario here, where the only purpose of the company is this scheme. So that was my brief run through part two. Part three. Well, I probably don't need to again dwell on this particularly long, but your lordships will appreciate that our case on purpose is pleaded in paragraph 24 of our points of claim, and that in turn sets out our case in relation to purpose, and we should probably briefly go to it. It's behind tab 11 in the core bundle at page 115. And your lordships will see it's put on the basis of a section 423 A or B case. And it draws from the earlier pleas in the earlier paragraphs, so far as the scheme design. So it takes us back to paragraph 11 more generally, but also you can see within, for example, little 1, over the page 116, it takes us back to also paragraphs 3, 9, 10 and 22, how the scheme was designed and operated. You then have the reference to the insolvency scenario, which I've already addressed you, your lordships, on. I think I've also addressed you on little 3 as regards the scheme would only been able to operate successfully on an understanding of a sharing of monies which ought otherwise to have been paid to HMRC. There's the feature of the offshore trust, which I've already dealt with, and then the modifications, which I think I've also dealt with. Just briefly going back to some of the earlier paragraphs, those are paragraphs 3, 9, 10, 11, 22. So 3 is summarising what the scheme was and how it was intended to operate, including the use of the trust. 9 is then explaining how business is coming in through certain consultants who are employed to try and encourage people into the scheme, and the company, as part of its bargain, providing services for which it would get an administration fee. And then in 10 we have the operation of the scheme, and which is in similar terms to what the judge finds in in paragraph 30 as regards the finding as regards what the scheme was, but you'll also note that through to little e, there's reference to the use of the trust and sub-trusts and the payments via discretionary loans, and the plea was never intended that the employee respondent would repay the monies to the trust. We then have paragraph 11, which in effect deals with the three relevant evidential parts. So the first part of paragraph 11 is dealing with the attractiveness, if you like, to the employee respondents of the scheme. And that's dealt with in the first sentence. The second sentence is then the second part, which is the design and the operation on the assumption that the company would not be required to deduct tax and national insurance from the monies paid to the trust. So that's, if you like, the focusing on the company's role rather than the employee respondent's role. And then we say, reflecting the secondary nature of our case with the words or to pay corporation tax, but, sorry, so it's the word but if this assumption was incorrect, the company would be liable to account to HMRC for any unpaid tax.
Part of the sentence starting with but if,
Yes.
is that something that on your case you attribute to the company, or is that simply the consequence of the assumption being falsified?
No, we positively attribute it to the company because it forms part of the attractiveness of the arrangement to the person who's been brought into it.
So, in other words, your case, and I think this may be your secondary case, is that so far as the company subjectively was concerned, its approach was, well, if this scheme works, that's great. And if it doesn't matter because we haven't got any money.
Exactly. It's to go back to the very old cases, which I think even preceded the was it section 172. It's a case of if it succeeds, we'll make a fortune.
Yeah.
If it fails, we'll not.
Those are the cases of people transferring everything to their wives before
Exactly.
starting up a
So
new
we're
business.
in exactly the same category here. And it is slightly complicated mentally because you are having to consider, as part of the company's intention, why it's doing what it is vis-a-vis attracting people into the scheme, which is, of course, the respondents, why it's attractive to them. So it does involve looking back, and that's why I thought the tax purposes were unallowable purposes cases were quite interesting from that point of view.
So, paragraph 11, you say the company subjectively knew.
It knew it was going to be primarily liable in relation to if it fails, because that's the consequence of the pay rate regime. If HMRC's challenge to this pay remuneration succeeds, then it knows it's going to be liable, and it knows it doesn't have the assets.
Yeah.
That's very simply.
And it's not enough that it should have known. You say it did know.
It did know it, yes. Yes, not should is not enough. Your lordship's quite right. It's not an objective test, it's a subjective test. And
so if evidence had been given to the judge and he accepted it, that we never gave a moment's thought to the possibility of failure, that would not establish your case.
If Mr Webster and Mr Webster or Mr Clark were called to give evidence and they established that and the judge accepted that we didn't contemplate failure at all, then yes, we wouldn't have a section 43 case. It's subjective. So we do rely on the features of this which show this is risk taking. This is in the we respectfully submit this is in the same category as the case of Atlas Bank and Jones, where you may recall there's a sort of sale and leaseback arrangement involving agricultural property, and the judge they get advice and they say, well, you know, this is the advice about how you set up the scheme, and they think it's going to work because their advisors tell them it's going to work. doesn't really matter. I think the memorable phrase used by Mr Justice Newey, as he then was those who live by the sword die by the sword. And the fact that you have professional advice doesn't negate your purpose, being a Section 43 purpose. And there are similar observations to that effect in cases like We've not Latham.
That's a rather different case, isn't it? I mean,
Is it?
there you've got a farmer who's got a large mortgage. He wants to stop the bank from repossessing the farm, i.e. not to be able to enforce its mortgage. So there's the purpose for you. And he's told by his lawyers, well, you can do it this way, and then the bank won't be able to displace the tenancy that you're going to be given instead of having the freehold.
Yes.
So the purpose is there. The purpose is absolutely plain. Right up front, we want to stop the bank from repossessing the farm.
And my lord, I don't disagree that each case turns on its facts ultimately, and insofar as our appeal might be construed as suggesting some general proposition which applies in all cases, I can't make that submission. I don't make that submission because Section 43 is a subjective test which is to do with purpose. I suppose that the feature which we say the judge really didn't recognise in this case is that what lies at its very heart is recognition that a liability will arise unless you take certain steps, which forms an inherent part of the scheme. And to draw on those authorities, it must be the case that that the people who are setting up the scheme contemplated risk. You can see that from a fair reading of all the materials. And number two, that if that risk eventuated, the scenario was creditors were left without.
What if you think the scheme probably works, and that if you're going to operate the scheme at all, you have to take all these various steps?
Yes.
Suppose additionally you have in mind that if it turns out that the scheme doesn't work, well, that's life.
Yes. So I think there is.
Is there a 43 purpose on your secondary case there?
Yes. So I think there is a category of case where you have the risk in contemplation. You think it's more likely than not that you will succeed in your endeavour, but nevertheless, in case of failure, you have in mind that the particular features which are intrinsic to the scheme will be a Section 43 purpose.
I mean, just to be clear, is there a distinction between the case where you have in mind the risk and you take a step to further that risk, and on the other hand, a case where you have in mind the risk, but it's not actuating your behaviour at all because the main purpose dictates the same?
Well, I think we then get into the debate, don't we, as to is it an intrinsic element or is it just simply an incidental feature type? I think that's where we end up in terms of subjective knowledge. If it's merely an incidental feature, then someone has the submission they can make that it's not only did we think this was going to succeed, but this wasn't actually a feature which formed part of our purpose. Then you can see the attraction. But if the mental element is we think this is going to succeed, but in any case there are these features which we positively intend, which will result in us being in a category of we make a fortune if we win, but we leave our creditors with nothing if we lose, then we're into Section 43. If that is an intended, if that is a
and that's a question of fact.
It's a question of fact, and you need to get past the question of necessarily, of course. In that scenario, you're dealing with a situation where your finder of fact may be more willing to accept the evidence. If someone comes along in response to a prima facie case and says, well, there's a prima facie inference here that you did have this purpose, but then they adduce evidence and the court accepts that evidence, then the court you may be back in the territory of the example posited by my Lord or Justice Lewison. The unusual feature of this case is absolutely no evidence is adduced to to rebut that natural inference, which we say derives from the design of the scheme. And the judge just simply didn't. I think his words were, "You've adduced no evidence at all." I mean, we interpret that as no direct evidence because he goes on the Luxar case on inference, but he seems to sail past or not really address the key part of our case, which is as well, it's inherent in the design of the scheme that is the purpose if it fails, and that does obviously prejudice the creditor who's making the may make a claim. I'm conscious of time moving on, and that I said I was going to do a lot more than I've got to so far. Section 43 interpretation was my next heading. I think I can probably summarise my submissions by saying this, and just to reiterate the points which I've already drawn your attention to. If you have section 423 up, I think it's in the authorities bundle behind tab 1, page 3 from memory. Your Lordships will have fully in mind the observations of the Court of Appeal already in a number of Section 43 cases on this being a carefully calibrated scheme, which needs to be obviously read for the purposes of interpreting subsection 3 as having regard to the part it forms part of and the other sections. In relation to the section 423 interpretation points, in our respectful submission, there are 3, sometimes you might say 4 if you split up transaction undervalue, but there are 3 conditions before you even get into the question of discretion. So we have the first threshold condition is the victim condition, which actually you need to go to section 424 for, which is over the page at page 5 of the authorities bundle, where you see that there's identified those who may apply for an order under section 43. And that obviously includes office holders as a class on behalf of all victims, and it also includes any victim of the transaction as well. And those are the only persons who may make an application under section 423. Going back to section 423 for the purposes of victim, you see the definition of victim within section 423(5), and so therefore, in order to qualify as a person who can bring an application outside an office holder scenario, you need to identify a victim of the transaction, and that is a person who is or is capable of being prejudiced by the transaction itself. Without that condition being satisfied, you don't get into section 423. And in our respectful submission, it's important you don't sail past that threshold requirement, because there's no standing to invoke section 423 without it. And your Lordship, I think your Lordships already have my submissions as regards how this impacts on the homely examples of lawyers wanting to provide for their children, etc. In the context of a lawful tax avoidance scheme, you won't have the victim.
Can I just understand that? Let's take a simple case. Somebody makes a gift to his children. Then years on, it turns out that for some completely different reason, he has a tax liability, which isn't surprising because obviously people accrue tax liabilities all the time. And it may be that at that stage, the revenue can't recover because the TAP hasn't got any assets because he's given away the money earned. When you enter into the transaction, make the gift, you are prejudicing the interests of someone who might in the future make a claim, because the revenue might perfectly plausibly make a claim, not because of the transaction, but anyway. So are the revenue a victim?
So if the tax planning is lawful, and therefore HMR.
I suppose it's not tax planning at all. You're just making a gift.
No. So I think you need to. I think for the purpose of the important thing, I think for the purpose of section 4233 purpose, you're looking at it prospectively, aren't you? The purposes of section 424 and subsection 5, you're looking at it retrospectively. So the retrospective question is, in effect, are you an actual creditor or a potential creditor or a person who might have an interest via that relationship, if I can do it that way? Because it's wrong to say it's restricted to actual potential creditors, because you can have somebody who's subrogated or potentially has a knock-on relationship, if I can put it that way, with a creditor. But you still have to have a person who has an interest in the estate, who has a claim on the estate on that scenario. So there are unusual scenarios you can posit where the person who you have as your target initially under section 4233 is not the same person who actually becomes the victim later on.
No, I follow that entirely.
So you may have a scenario where you don't initially have a victim, but then someone comes along as a victim and says, well, this was an asset depletion exercise which had the purpose subjectively, obviously you have to cross that threshold, and I am a victim. And then the court would then interview a question of discretion. Is this a category of case which I think is appropriate to, and those facts may be very relevant on the question of discretion.
And I follow all that, but I just wonder whether in the circumstances the victim requirement really has any significance. So suppose I give away my assets because somebody other than the revenue might have a claim against me, and therefore I am enter into a transaction to an undervalue with a prohibited purpose.
Yes.
And then the next year it happens I have a tax liability.
On something different.
On something entirely different.
Yes.
And the revenue are prejudiced because all the assets are gone. Well, is not the revenue a victim?
Yes, it is in that scenario.
In which case, what significance in our context is to be attached to the requirement for a victim?
Well, in this sense, does it shows, does it not, that the gateway for relief as a starting point has someone who has been impacted by an asset depleting transaction where has the requisite purpose.
Just leave the purpose out of it for a moment.
Yes.
If we assume you've got an asset depleting transaction with a relevant purpose,
yes,
it's enough, isn't it, that you're worse off because of what happened? It doesn't. The transaction doesn't have to be directed at.
I know. I agree with that. Yes, I think Hill and Spread establishes that.
So it's good enough that the revenue just happened to have a claim for some completely different reason, and the assets are gone.
Yes, or even not the revenue, some other creditor. So your lordship's right that Hill and Spread establishes the proposition that section 43 isn't to be read with an implied restriction that the target of your prejudice, if I can put it that way, the target of your asset depletion transaction is the person who is the complainer. So there's no causal, according to the Court of Appeal in Hill and Spread, and I don't think either of us are arguing to the contrary before your lordships, that the courts have not read into a restriction in that respect. You just simply read the words of the section and ask yourself, do they respond? In my respectful submission, the fact that there isn't that linkage suggests that actually the section 43 has a broad reach. It's a deliberately broad reach, and ultimately the end point is the court is asking itself the question, either individually or as a class, have you been prejudiced by this particular asset depleting transaction? It's interesting to note in the context of the Scottish jurisprudence that the equivalent of the Scottish jurisprudence just simply has to have an asset depleting transaction insolvency. And there's no purpose there at all, actually, as part of the Scottish requirements. Of course,
what is the distinction between a person who is prejudiced by it and a person who is capable of being prejudiced by it, as we see in subsection 5?
So I think.
So can you come along and say, well, actually, I haven't been prejudiced by this at all, but I am capable of being prejudiced by it.
So I think that typically I think is intending to deal with the scenario, isn't it, where lots of these cases are bank cases, aren't there, where there's not yet been an insolvency event, but you can see that's potentially coming down the road if the defaulting debtor is allowed to get away with what they're doing. And so they, rather than waiting for the insolvency, they go in. But if the scenario is this is a solvent estate, there is no question of you being prejudiced even if there is an asset given away. You're not in Section 423 territory. And that's why it's in the Insolvency Act, albeit at the back of the Insolvency Act and its own particular part. So that, I think that deals with that point. But that was the reason why I think I understand and hopefully address the points you raised about the role of victim. But I think it is when one is stress testing, does the second limb of my primary case prove too much, which I think is the sort of debate we're having. It is relevant to ask the question, well, in examples you posit, do you actually have a victim? And obviously you can add layer on layer to these examples to test them and more and different examples. But in our respect for submission, that is a relevant factor to take into account. The second, obvious threshold condition or condition is value depletion.
Is what?
Value depletion under Section 423(1), and obviously then the third is the purpose element. I haven't taken your lordships yet to El Husseini in the Supreme Court. I don't know if your lordships had an opportunity to look at it yet or not.
I'm not sure that really sheds much light on the question of purpose, does it? It's about
No.
the transaction.
It's focused on the question of transaction. Perhaps I could just deal with it at a high level in this way to say that it supports the approach to interpretation, which I think we would advance before your lordships as regards how Section 423 is to be interpreted. And
It supports a broad interpretation.
It supports a broad interpretation. It supports the proposition that you shouldn't read implied restrictions into or qualifications into Section 423.
Yeah.
And we would say that on either our second or third limb of our primary case, that's precisely what in effect is happening, that you're leading in a qualification or an exclusion which just simply isn't there. I think.
Are you going to come to the wording at some point?
The wording
of Section 423.
Yes. So back then to Section 423(3), as regards the question of A and B, limb A and B. In relation to what this contemplates, it's important to understand that in relation to both limbs A and B of subsection 3, that it's contemplating a person who is not simply is making, but may at some time make a claim. And that in our respectful submission shows its wide reach. It encompasses even the cases of people who entering into a risky venture, just in general terms, think, well, this will help with protecting my position. You don't have to have an identified or identifiable person, though if you do have an identified or identifiable person in our respectful submission, then you would more naturally be in the territory of a case where the court is willing to draw the conclusion or the inference that the purpose has been established. So it's a factual question, ultimately, as to whether or not you fall within or without those words. And on the second limb of subsection 3, in our respectful submission, this is widening even further what you have in little a. So it's not just putting assets beyond the reach of a person who is making or may at some time make a claim against him, but also B, or otherwise prejudicing the interests of such a person in relation to the claim which he is making or may make. And the concept of interests here is a wide one, as per Lady Justice Arden in Hill and Spread. It isn't just fully focused on rights. So the mere fact that HMRC, for example, may be able to make an assessment doesn't mean that you're not seeking to prejudice their interests. And it's in relation to this second limb, we see the words in relation to the claim which he is making or may make. And it's important to understand that that is contemplating not simply someone who is making the claim at the time, but may make in the future.
So can we just unpack it? You, for the purposes of your primary case, you rely on B.
Yes, principally B, because we say it's wider than A. For our secondary case, we say A or B.
Yep. So
A and B might be more accurate way.
Can we take the sort of example that Mr. Bayfield contemplates, where you give away assets in the hope that you'll live 7 years, so there'll be no inheritance tax paid? Now there, the aim is to prevent any claim from arising. Now, how do you fit that into the claim which he is making or may make?
So I think if we're dealing with the scenario, I think which one are we dealing with? Sorry, are we dealing with the milliner scenario of?
I was taking the milliner scenario.
Yes.
Maybe even that's not.
So I think
the best one. Maybe the successful lawyer is the best one. I'm not sure.
Well, on the milliner one, if we just briefly deal with our submissions on that, we say that on the fact posed there, it's at least arguable that you wouldn't fall within section 423 because HMRC is arguably not a person who is making or may at some time make a claim against the milliner, because the inheritance tax claim would only arise against his deceased estate following his death. I'm not sure if actually you would necessarily have a section 423 B purpose in that scenario. You wouldn't have a victim either, because HMRC hasn't actually got a claim that they can lawfully make.
Well, they haven't now, but they may have if the milliner dies within 7 years of giving away the business.
Well,
So why aren't they a person who may make a claim? Maybe contingent on the milliner's death, but why not?
If the finder of fact at first instance finds that the requisite words do apply to the specific example in kind. The difficulty we have with some of the examples they pose, they don't really actually home in on the question of, is HMRC someone who is making or may at some time make a claim against them and prejudice together in order to work out whether or not you actually have section 423. You can, on our primary case, contemplate a scenario where you do get through the section 423 purpose gateway test, because the facts respond. But we bulk at the suggestion, if I can put it that way, that this is a floodgates approach.
Can I put it slightly differently and more abstractly, because I can't necessarily think of a good example. Suppose it's perfectly clear, there's no doubt about it at all, that the scheme used in this case works.
Yes.
With the result that by adopting the scheme, income that would otherwise be taxable is not taxable. Just suppose that's the case. So that the objective of the scheme is to prevent the liability arising. It works. The liability will never arise. HMRC will never have a claim.
Yes.
So how could the wording of B operate in that situation? Because HMRC is not making a claim, and it can't make a claim either, ever, because the scheme works.
Yes, well then it can't. I'll accept it. If the purpose is not to prejudice interest of person in relation to claim, which he is making or may make, if there is no claim which can be made, then you can't have a subjective intention to prejudice that claim.
So if you intend to do something to stop a claim arising, that's not a prohibited purpose.
Say for this qualification, that if the way you, the means you do that, or the way you do that, involves an element of delay, hindrance, disguise, etc., then in our respectful submission, in that category of case, you do end up in a scenario where you can, and depending on the facts, would have an intention to prejudice the interests of a person in relation to a claim they may make.
Well, what claim, if it works, what claim might they make? I mean, they can't.
Well, because in relation to that scenario, even if they can't, your objective purpose is to defeat them.
It's to stop a claim arising.
Yes.
I mean, you say you can't imply a word. I wonder whether you're implying the word otherwise. So you're saying in relation to the claim which he is making or may otherwise make. And I suspect in your skeleton you more or less do that.
Right.
I mean, if you take, say, paragraph 19 of your skeleton,
Yes.
You say, by seeking to avoid incurring a liability, blah, 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 the company sought to prejudice the interests of HMRC in relation to the claim it may otherwise make. So is the truth really that you're seeking to imply the word?
Well, no, in the sense that may make simply contemplates a potential future claim. So the wording of the statute does not restrict the scenario to the situation where there is an actual claim. And if the wording of the statute does not restrict you to the category of an actual claim, but a potential future claim, ergo, you can have a situation where you don't yet have a liability to anyone. And then it becomes a factual question on the facts of your particular case. Are there features of this transaction which mean that you are seeking to prejudice the person in relation to the claim they may make? Now, I can see that the contrary proposition, that the contrary argument would lead us to our secondary case. So if your lordships were against us on that, I can see that that might lead us to our secondary case, because you would then say you're reading prejudice in effect retrospectively, I suppose. But it's a prospective test, I think, section 4233. So the legislation posits a future scenario where you have a future creditor, and doesn't in our respectful submission restrict it to a scenario of prejudice which is to in effect to defeat the claim in its entirety, to stop it arising in its entirety. And that is the logic of our second limb submission, if I can put it that way.
Well, is it quite, I mean, let us suppose the state of mind of the person who is about to enter into the transaction is, I've got this scheme, if it works, that's great, and if it doesn't, I've got no money. And it works.
So after the event it works.
423?
No, so if it works, we don't get into section 423. That's why I think the stress testing it by reference solely to section 43 on purpose, you may lose sight of the other parts of Section 423 which are required.
I think you're accepting what my lord put to you, that doing something to stop a claim arising at all is not within Section 423 unless you contemplate the risk of failure and go ahead anyway.
So I think, so if we're dealing with a category of case where your mental state is you contemplate, is you have no, there is no assessment of any risk of failure at all, then the factual question then posed is can it be said that this person subjectively intends to prejudice the person? That may be difficult, perhaps, I can see that.
But it's not just prejudicing the person. I mean, there is
In
no
relation
person.
in relation to the claim which they...
But there's no expectation that the person is making a claim or may make a claim, because the idea is that they can't make a claim.
Yeah, so on that hypothesis, I think I probably would need to accept that in that scenario you probably don't have a Section 423 purpose, because you don't get your subjective finding that you need. One additional thing that I thought may assist your lordships is a sort of a recent addition to the authorities, which your lordships may not yet have looked at, is our submission on the question of the word prejudice, and it may be that this isn't a controversial point, so I can deal with it very briefly, is that on the question of word prejudice, it's an ordinary word which has no technical meaning. And so it's simply a question for your lordships to assess, or for the first instance, fact finder to assess more precisely, whether or not the facts are responsive to the ordinary word. But if your lordships want some further flesh on the bone, so to speak, as what prejudice means in this context, I don't think anyone is disputing that it's in effect synonymous with the concept of harm. That's what we're dealing with, and if your lordships want further relevant discussion, one needs to be a little bit careful with the court report, because of course the court report was contemplating a more limited reform than actually happened under Section 43, but we thought it might assist your lordships to have the relevant passages in the court report, which is, I think, with you behind tab 37, with the supplement which you should find on your desk. And you see there's a brief discussion within it at 1212. I think it's page 276 internal. There's a brief discussion about what was caught by Section 172 provisions, according to the case law. So we see the words defeat, hinder, delay, or defraud. We would respectfully submit that the concept of disguise is itself a
We're not in that territory in this case, are we? I mean, if there is no prohibited purpose, then there is no prejudice. On the other hand, if there is a prohibited purpose and HMRC can't get the money, they're obviously prejudiced.
Yes, so I don't think there is, as I said, I don't think there isn't really any significant debate as to me.
As you know, Mr. Sims, we tend not to decide things we don't have to decide.
Well, in which case, I just wanted your lordships to be aware that so far as our position is concerned, it's a non-technical phrase which simply is applied. My lords, in relation to time is marching on, so I think I should probably deal with a few brief points in relation to the secondary case now, in relation to the particular reasons why we submit the judge erred in the court below. And my lord, in relation to the starting point for that, as I've indicated, the first limb of our submission in that respect is the failure by the judge to appreciate the features of the scheme, which we say which inference can be drawn. I should probably just pick up the relevant passages in the judgment and just take our way through them. So far as the judge is concerned, I think it starts at paragraph 50.
50, yeah.
So it's tab 7. This is where he deals with the secondary case. I think your lordship already have our point that we respectfully submit our pleading case, and our case argued in the court below was both limbs A and B. But I suspect nothing huge turns on that. It's a question of really what evidence there was. And then you see he refers to the decisions in Marylebone, Warwick, and Assertis Limited and Keithhead. And I've already made overview submissions by reference to those two cases. There are some difficulties in our respect for submission with some of the reasoning in Marylebone, Warwick, but nevertheless, they're both very different cases in fact in this case. The Assertis case actually posits a scenario which in our respect for submission is very close to the scenario we're dealing with here of a tax avoidance scheme which has risks associated with it, which results in a situation of creditors being left unpaid. He then goes on and then deals with what must be shown in paragraph 52, and I think I've dealt with the phrase no clarity. The second sentence I've already dealt with, and you've already had my submissions on the primarily why we...
Do you quarrel with what he says at 50, in the first sentence of paragraph 52?
Insofar as it impede HMRC from recovering tax due to HMRC, if that is in effect the judge's shorthand for prejudice, I don't.
What the judge is saying is a purpose of the company in setting up the scheme was if it failed, HMRC would be delayed. So, in other words, the company knew when they set up the scheme if it failed, the HMRC for HMRC to recover the tax. Do you quarrel with that as a proposition, not a fact, but of what you have to show?
I don't think there's anything significantly wrong with that articulation. In a sense that it's a shorthand way of the judge describing what you need to meet under the test of delay, hindrance, etc. So it's what follows really, which we quarrel with, which is the first we say that there was no lack of clarity. We relied on both those features in the court below for the reasons I've articulated. And then at the end of paragraph 52, he says the closest Mr Sims can point to is the fact the company advised the response they did not need to disclose the loans that they were receiving from the trust to HMRC. And then he says that is consistent with the belief that the scheme worked. And he then goes on to say Mr Sims also points to one exchange after HMRC's inquiry began, which he said the company deliberately failed. Now, before moving on to paragraph 53, in my respectful submission, the judge, by just simply saying, well, that's consistent with the belief that the scheme worked, is not actually meeting the secondary case which is advanced there, which is, well, the factual scenario we're dealing with here is if the scheme didn't work.
Yeah, quite. So your secondary case is the company appreciated, to use a neutral word, that if the scheme failed, the company would be left holding the baby with no assets.
Exactly.
That's your essential point.
Yes.
Now, if the company didn't appreciate that, then your secondary case fails, doesn't it?
Yes, it's a question of fact.
Yes, so the question for the judge is that something the company appreciated?
Yes, and that is not met by simply considering the question of a belief that the scheme would work. It's inherent within it is you are contemplating a scenario of...
Well, it doesn't.
It doesn't, yes.
Yeah.
Secondly, in relation to paragraph 53, we referred the judge to an exchange where we say there was a deliberate failure to provide information, and the judge says, I do not consider the exchange of correspondence relied on justifies that inference. And we have difficulty with that conclusion, but with this, he then goes on to refer to the relevant correspondence, and he recites Mr Clark responded on behalf of the company on the 8th of November, responded to those requests. And he says the tenor of the response is that most of HMRC's requests have been satisfied. The response confirmed the threats employees have received loans and that the company did not have access to trust records. The company was unable to provide details of loans made. This seems to be incorrect. Nautilus did not share trust information with the company. It was not entitled to it. Apart from haphazard emails between some respondents and Nautilus, where the company's liquidator has not found any records as to what loans were made to the response from the trust. And then he deals with a further submission I made, which is that the response fails to answer requests to identify dates on which payments have been made by the company to the trust. But he says the request is poorly worded and combined with a request for information, which was trust information. The company's response has responded correctly if only Nautilus has trust information. And I respect for submission, this doesn't really address the point which we were taking the judge to. And as it happens, on the documents, it doesn't address the point we were taking the judge to. If I can take your lordships to the specific documents where this particular point was played out, it's in the supplemental article. It's the letter from HMRC. I think the one which immediately responded, the response is at tab 14, starts at 120. There was an earlier one, but I'll just take the most proximate one in time. And then we have at page 124 a list of various questions, and you see information required. Do you see questions number 6 through to 9 at the bottom of that page? I'd invite you to just read those to yourselves, please, if you haven't already done so. So your lordships will see in particular in 9, what are the dates on which the payments or transfer of other assets were made by Ethos Solutions Limited to...
Where are you?
That's right, bottom of page 124.
Yes. Question 9.
Question 9. I just reading that out. What are the dates on which the payments or transfer of other assets were made by the company to the trust? In what form, where these assets held? So the company does know the payments made by the company to the trust. And then a response back from Mr Clark on the 8th of November 2011, page 125. The relevant part of it is the information required heading. Can you see that at B126? And you see B127, the responses to questions 6 to 9. That there were other questions as well. I'm just heading in on these 4.
Yeah.
Question 9. This information is the sole possession of Nautilus Trust. Well, it's not. And we don't understand how in those circumstances the judge reached the conclusion he did in his judgment. We note in passing also, in paragraph 8, we understand that some of the employees of Ethos Solutions have sought fully commercial loans. Your Lordships will remember in the frequently asked questions document, which is actually also recited by the judge in his judgment, and it describes the loans as not commercial loans. So what is this if it is other than a seeking to hinder or delay HMRC? Going back to the judgment.
So you say, let me just get this right. These are incorrect and or misleading answers to questions properly asked by HMRC,
which go to the
albeit a year later,
which go to the
but that you can infer backwards from that this sheds light on the purpose of the company in setting up the scheme in the first place.
Absolutely, because it goes to the very same question of the disguise.
Yeah.
And then at the end of paragraph 55.
Sorry, can I just follow up that one? You've accepted what I put to you, that you can infer retrospectively
Yes.
that the purpose of setting up the scheme was a prohibited purpose.
Yes.
Let me put the question a slightly different way.
Yes.
Must you infer retrospectively that the company had such a purpose in setting up the scheme?
Well, we draw the word "must" from the decision.
Well, if it's a question of can you, then that's really for the judge to decide.
Well,
If it's a question of must you, then we may say that by failing to
Yes.
draw that inference, the judge was wrong.
Well, we say it's a must question because it's inextricably part of the scheme features. It's not.
Well, that is in itself an inference, isn't it, from an answer given a year after all the events with which we are concerned.
Well, I think not in this sense, that even before you get to this exchange, you have the question, why is the scheme designed in the way it is? And I would accept your Lordship's proposition that perhaps without that this submission has less force, but coupled with it, it's incredibly powerful, and it's demonstrably wrong for the judge to not only have got an incorrect reading of the document, but also to have not joined the dots between the original purpose and that this is actually what you see here is playing out precisely what we say on the alternative case of section 43 purpose. It's a plain wrong scenario in our submission. Now, back to the final point on the facts. The judge. Is a puzzling reference right at the end of paragraph 55. The judge says, on the contrary, I note the company openly identified in its filed accounts the total of payments made to the trust. That's simply wrong. And if you go back to the accounts, they don't disclose the payments made to the trust. They're not identifiable as such in the reported account. If we go back to the accounts, they're within the supplemental bundle IOB behind tab 3, and it starts at page B17, and you see the overheads at B25. Well, I'm conscious of the time moving on.
So these are other staff costs. Is that where they're...
That's what we discover on further probing as to what this is, but it's not disclosed. That's the simple point. And from the point of view of HMRC and its position, the reality is it has to liquidate the company in order to then try and dig further to work out what the payments are, how they've then flowed through the scheme, and even then, we're obviously met with the obstacle of the offshore trust. Unless there's something further.
Can I just be clear? In this context, it's your case that the judge should have concluded that in setting up and operating the scheme as it did, the company had as a purpose that
If the scheme,
in the event that the scheme didn't work,
yes,
the HMRC would not be able to recover.
HMRC, in effect, the primary liability for the company would be
So
no asset.
just to be absolutely clear,
So-
what you pointed to what you say are errors in the judge's approach. What are the indications that you say should have led the judge to that conclusion?
So the indications which we say should have led the judge to that conclusion are, number one, the fact that the company is primarily liable under the scheme. Number two,
Primarily liable under the scheme, and on this scenario that would be right, obviously.
number two, that the offshore trust structure, so using the offshore trust structure to divert the payments with the opacity that has, three, that in relation to, in particular, the loans, that the element of remuneration, which ultimately ends back down with the respondents, is a loan which, in reality, in order to make the scheme work, cannot be contemplated as being recordable. Cannot be contemplated as something that is going to be recalled. Four, that the company is capitalised on the basis of only £100, and if the scheme fails, it will automatically be insolvent. Six, that the very attractiveness of the scheme for the punters, if I can refer to it that way, is that this will be effective to relieve them of what would otherwise be an employment taxation liability, which would, in the ordinary course, have not entered into the scheme for or now. So it follows that in order for the scheme to be attractive to those who are entering into it, it will be more attractive if your objective is to try and defeat, if defeat fails, HMRC will be impeded in unravelling the scheme and coming after. 7.
I missed out one. I've only got to 6.
Oh, I jumped one. I probably did. But normally
You
council,
jumped 5.
normally council do it the other way around, don't they? Six then is the modification, the scope modifications. So you may recall that.
What, post 2010?
Yes. So what we say is this wasn't a scenario of those who control the company saying, okay, fair enough, game up.
No, they responded to a proposed change in legislation.
By causing the structure to be altered so that the employer is an offshore company. So it does so.
I don't know what you get out of that.
Well,
I set up a scheme based on the legislation as it stands, and I am 100% confident that it works. Then the government proposed to change the legislation, and I appreciate that if the legislation changes as proposed, the scheme I've set up won't work. So I change it so that it does comply with the
I suppose the way I put it is this, my lords, is that does it not show a propensity on the part of those who are controlling the company to, come what may, come up with a design which avoids the liabilities arising?
Well, that's one way of putting it. Another way is it shows a propensity to comply with the law.
Well, your lordship's clearly not taken with that point. We thought it.
Better ones.
And my lord, I think it comes as number 6, or 7 if my counting was accurate. So, but my lord, the judge didn't take that one into account. He didn't. We thought it was a valid point, but your lordships may think not. We do think it discloses a propensity, but there we are. My lords, I'm conscious of the time and probably should give my learned friend fair time and also for other points to be ventilated. So unless there's anything further I haven't addressed.
No. All right, thank you very much. Just give us a few minutes, would you? Don't leave the court.
All rise.
The transport I didn't realise must be some benefit accruing to the company. Future stuff, yeah. We do with this in more space. Yeah.
Especially if a couple can decide to bounce a few ideas to each other before then sending a bolt at you. Throw it back to 19 years ago.
Yeah. Unless that can happen with good feel, sometimes they can just say. Because sometimes they do that. So I'm understanding the case. I've had that.
I just think one thing I flagged up in front.
Oh yeah, no, I understand. I do understand that.
So how many died in that scheme? 6, I think.
You could do it before.
Yeah. I said, so what my 6th one is the one he didn't bring.
These two don't.
This is the biggest
Those are very clear prescribed scheme. So you don't go through and tick this box. There's a degree of artificiality that was not necessary, it was only to achieve the allowable purpose. Whereas like on these ones, there was really
We needn't trouble you, Mr. Bayfield. We will dismiss the appeal for reasons to be given in writing later. You will get a draft judgment in the usual course. It will contain a fierce embargo, which means what it says. That's your opportunity to correct any typographical and other grammatical errors, and we would hope that in the light of the draft judgments you will be able to agree in order disposing of the appeal. The judgment will eventually be handed down remotely, so there's no need for any further attendance. Thank you very much.
There was just one point that I should probably correct.
Yes.
My colleague has drawn my attention to the fact that whilst it didn't form part of one of my submissions at the end when I gathered together the submissions, I did at one point criticise the judge, and I think we do in our skeleton argument as well, criticise the judge for suggesting that the accounts and the entries in the accounts disclose the figure was to the trust. And we say
You showed us the accounts. That
yes.
sort of wraps up in other staff costs.
Yes, but my co-leader has spotted that elsewhere in the accounts, that figure is disclosed as showing being paid to the trust.
Oh, I see.
So I wanted to correct that
Right.
because
Can I give you the bundle reference in case helpful?
yes,
Oh, have you got it? Sorry.
yes, I was going to draw it's a supplemental bundle at B21, and it's exceptional item number 3. So we were wrong to criticise the judge as it happens for that point, which we've now just spotted.
Yes.
Which page?
It's B21.
Note 3.
Note 3.
Yeah.
And if it had made any difference, I was going to make the submission that the opacity kicks in relation to unravelling how much of each of payment is responding to each respondent, rather than the fact that there's no trust at all. I think, as your lordships may have pointed, there was a DOTAS number in any event in this case, so perhaps that point would have struck home anyway. But I thought I should draw that to your lordships'
Thank you
attention
very much,
because
Mr Sims.
I think it may feature in your judgment. I'm fairly on the judge.
Thank you all very much.
All right.
That's definitely what I do. You tell everyone. Thanks, gents.
Cheers, good to see you.
Thank you.
Thanks.
Oh, it's just down there.
John needs
I'm not I have had experience. We've done what we can. Yeah.
I thought you did really well.
Yeah, a lot of work went into that.
I know, I thought you did really well.
Maybe on, on reflection, maybe the really telling comment was when Justice Lewison said, you know, I'm happy to decide things you didn't decide.
We can dispose of this just because it is a finding new fact by the judge as to what was he was against you.
There was a child and he was prepared to write it down.
Yeah.
Got pages of stuff still.
Huh?
We've got pages of stuff still to say.
All over, right?
Yeah. Oh, well, at least it's not the safe. Oh.
You could laugh or you cry.
It's only been about 8 years in making mistakes, so I don't know.
Should we go and have some lunch? Or does everyone want to just go off and
I think we probably have some lunch after that.
I know you shoot back.
Yes.
So you know, shoot back. Becky's come down with tonsillitis and stuff.
Yeah.
An hour and a half sleep last night. Go back up and relieve her, then she can get some bed rest.
Get some brownie points.
Something there would be over here.
I feel like Jennifer's been shortchanged. She's only seen
Well, that's effective advocacy, just it had, didn't affect the one we're hoping for, but
in theory about the dynamic.
Which is what the one of them was initially attracted, maybe gave permission and then got lent on by more senior. Perhaps.
Have I ever?
That's why I'm just, that's 2-0 now, my experience of being
Actually, I have succeeded from Lewison, but fair easy one, but he was a dissenter. Yeah. Right.
It's quite a sad way to reflect that unless we do get this brief on this one, that was the last time we ever appeared together in a case.
Well, you never know. Maybe a big blockbuster case comes along which merits 2 silks. You do sometimes see that in Supreme Court. Sometimes more than
You can tell ourselves being against or in front of each other.
no, you're right. Yeah. That's all your efforts, Simon. Prepare. Yes.
Clearly hit the spot.
Not for once trying.
Just also for Jennifer, because she missed what would have been some very persuasive and powerful advocacy from the government.
TV stuff, yeah.